Let's bring back in Martha Coakley, former Massachusetts Attorney General. Martha, are you surprised? What's your reaction?
So this is pretty much an entire victory for the defense. This is a verdict that they can live with, that the defendant can live with. The jury did not find the Commonwealth proved its case that somehow she was responsible for John O'Keefe's death. So it's almost, not quite, but almost total vindication for her.
Well, Martha, this all comes down to those two words, reasonable doubt. And we knew that the defense was making a good case for reasonable doubt. You said that earlier in the first case they did that, and in the second case as well. So if you, reflecting back, what do you think they did well that convinced this jury that they could not convict?
Well, look, as we just spoke, the closing is really important. And Alan Jackson is a masterful storyteller, was able to weave this together. The defendant apparently was able to create some sympathy for herself or some bond with the jurors. You know, one issue always is there was a lot of technical information at some stage in the trial. The prosecution went to great effort to do this. And I wondered at the time, and I wonder now, if some of that just went in and over their heads. You know, a case can be careful with lots of data, but sometimes you can have too much. And in the end, the story that the jury was able to find was the prosecution did not prove beyond a reasonable doubt that she had, certainly intended or done something to create his death or being involved with him. They just couldn't prove how he died.
And you could argue it would be difficult not to find the defendant not guilty of OUI, as the facts of the case were that they had been out drinking, kind of admitting to 9 drinks and driving her car.
And said she shouldn't have been driving.
So, I mean, that almost was a given, and we had that indication yesterday that the jury had honed in at least on OUI. While very serious, certainly the most serious charges here, she was found not guilty.
Yes, and recall in the first case there was no OUI charge. This was added by the defendants. I think knowing she had kind of acknowledged it, if not admitted to it, and that this was a way for the jury to do something to hold her accountable for that night. But there's always been this aspect of, did she even know what she was doing that night because of the alcohol use? And that may have affected the jury's decision as well.
But ultimately, even if you can't blame alcohol use, ultimately, that's not a defense.
Exactly. But people are human beings and they have common sense. And these charges about, was she responsible for killing him are very weighty. They're very serious. I'm sure they took that into account. But she is the one who has the rights here, that unless the Commonwealth can prove this beyond a reasonable doubt, they cannot convict her of anything related to his death.
And Martha, we talked about this after the first trial, but so she's only found guilty of OUI, which in many other cases, a first offense, it's essentially, it's continued without a finding. There might be a fine, right? I mean, this is a minimal offense in the Commonwealth, correct, for a first OUI? So 2 trials now, hundreds of thousands of dollars, millions of dollars spent by the Norfolk County DA. Was she overcharged based on the facts of the case to bring a murder charge again when we knew the first jury struggled with that, or may have even found her not guilty?
So it's a fair question, and this idea of overcharging is not really understood. The Commonwealth has an obligation in cases, and I've been on as a DA and an ADA, you are really required to bring the highest level of charges that the facts support. If you found the facts as they presented them to be true, there was enough for a jury to convict on that. Otherwise, defense would have moved to dismiss that charge because there was insufficient evidence to charge it. Having said that, it's an extreme charge. People think of murder intent. That didn't seem to fit the narrative in this case ever. And so it was a little bit of a stretch. And then you wonder, you only have so much credence with the jury when you try and stretch something too far. do you lose credibility otherwise? Defense ran that risk, by the way, too, I think, in some instances in this case, but here the prosecution always has to be telling the truth, being fair, presenting the evidence fairly, and giving the jury a reason to want to convict a defendant, and they were just not able to do it here.
And let me ask you quickly on that question of whether or not to bring the murder charge, at least the second time around. Do you think, as a former DA yourself, you feel a burden to do that because the victim in this case is a police officer?
I doubt that factored into it, to be honest with you. It shouldn't have. I don't think it did. I think that they had enough to deal with the idea that the defense was other police had killed him and left him on the lawn. So that wasn't a factor. And then, frankly, in the first trial, who John O'Keefe was and what he did got lost a little bit. Hank Brennan, as you know, brought that more to the forefront. I don't think the charging on this went to who John O'Keefe was in his day job, so to speak. But look, every DA who faces someone who's dead, who appears to have been killed, has that responsibility to speak for that victim. The defense has lawyers, they have all of their approach, but the only person speaking for John O'Keefe in this case was the Commonwealth. And I think that was based on what they saw in the facts that required some justice for John and his family.
And of course, the O'Keefe family, no doubt, feels no justice today. Karen Reed's future, the criminal case, it's now over. But there's a civil case.
And we know from other high-profile criminal cases where there's acquitted, I'm thinking of California and O.J. Simpson, there are many cases where the burden of proof is different. A civil case is easier to win. There are civil efforts afoot in some of these instances. So they probably won't carry the same emotion or the same level of attention, but those cases will also proceed and could come out very differently from this one today.